Hello everyone and welcome to the Regulatory Compliance International webinar series. My name is Divika Kapoor and thank you for taking out the time to engage with this webinar today. And today we'll be having compliance conversations with Dominic Wai, partner at ONC Lawyers in Hong Kong. Dominic is our legal expert for the Anti-Money Laundering and Counter-Financing of Terrorism module being developed for Hong Kong. So today, we will be going through the LexisNexis regulatory compliance product. Our legal expert will introduce himself. We'll go through the current legal and regulatory landscape and environment of anti-money laundering and counter-financing of terrorism in Hong Kong, the module scope, any upcoming trends in the area, our key priorities, and some questions from our customers. So now I will take us through what the LexisNexis regulatory compliance product actually is. LexisNexis is a leading global provider of legal, regulatory, and business information and analytics that help professional customers make more informed decisions, increase productivity, and serve their clients better. Our regulatory compliance product is a legal obligations register and an alerting solution that combines regulatory content with technology to empower you to take control of your compliance obligations. To develop these modules, we will use leading legal and industry experts to provide a practical, plain language interpretation of all of the relevant legislative and regulatory materials so that you don't have to. We are currently rolling out the financial crime modules, anti-bribery and corruption, anti-money laundering, privacy, and cybersecurity across several jurisdictions, including China, Hong Kong, Japan, United States, United Kingdom, and Singapore, with additional modules available in Australia and in New Zealand. And all the modules being developed in China and Japan are available in Chinese, Japanese, and English. So now I'd like to hand it over to our legal expert, Dominic Wai. Thank you so much for joining us today. Could you please give us an introduction on your background and your expertise?
Thank you, Divika. I have been a lawyer for over 20 years, and my main practice is in litigation, compliance, and regulatory matters. For the last few years, we have done a lot of matters on two fronts concerning AML. One is to act for clients to recover money as a result of business email scams or fraud, where we help clients to take legal actions and also liaise with the law enforcement agencies to freeze the money that are matters concerning AML. And on the flip side, we also help clients whose bank accounts might have been involved or implicated on AML matters that have been frozen, and we try to help them out to unfreeze the money. And we have also been helping clients who are money service operators, MSOs, on their license renewal and AML compliance matters. So we have ample experience in this area concerning AML and CFT. Thank you.
Amazing. Thank you for that introduction. Now, if you could please take us through the legal and regulatory landscape and framework of anti-money laundering and counter-financing terrorism in Hong Kong.
Sure. Now, the primary legislation in Hong Kong on AML and CFT is the Anti-Money Laundering and Counter-Terrorist Financing Ordinance, or AML or AMLO for short. Now, previously, it covers one type of institutions, but now it covers two types. One type is financial related. Those are financial institutions such as banks, licensed intermediaries such as securities companies or securities brokerage firms, insurance agents, and money service operators, MSOs, who deal with money changing business and remittance. And 2 years ago, it extended to cover institutions that are known as Designated Non-Financial Business and Professions, or DNFBP for short. That now covers lawyers, accountants, real estate agents, trust and company service providers for those who help others to set up trusts and setting up companies. Now, the AMLO mainly covers 4 major AML obligations. It covers a bit more. For example, like there is a licensing regime for MSOs or trust and company service providers, but mainly it covers 4 types, which is, I'll go into this a bit more detail in the next slide, but it covers customer due diligence, ongoing monitoring of client and transactions, filing of suspicious transaction report, and record keeping. Now, it also covers the regulators of those institutions that I mentioned, the 2 types, financial institutions and also the DNFBP. They also issue some guidelines that help the institutions to comply. Now, the landscape is that under AMLO, it covers mainly CDD. When the client is on board the company, then the company should take measures to identify and verify the identity of the customer. Now, if the customer is a corporation, then it needs to verify the beneficial owners of the company. And it needs to drill down to the ultimate beneficial owner who have control of 25% or more of the shares or voting rights of the company. And for some customers, they might need to take a so-called enhanced due diligence measures. And for that, the law and the guidelines suggest all companies to adopt a risk-based approach in determining the extent of customer due diligence that they need to take, and also in terms of ongoing monitoring. For example, the companies that are covered by AMLO would need to consider whether certain customers might be coming from or in connection with high-risk jurisdictions. There are countries in the world that fall under certain sanctions regime. And also the customers themselves, if they are individuals, whether they are politically exposed persons, PEPs. So the covered institutions would need to take risk assessment and consider whether the customer is of high or low risk. Based on this assessment, then the company would need to either take more due diligence checking, or they might need to consider whether they should accept the customer. Now, apart from the onboarding part, the existing relationship or ongoing relationship would need to be continuously monitored, because the customer status might change. They might not be in PEP originally, but they might become one today, or their country might be suddenly subject to certain sanctions. Apart from that, the company would also need to consider the transactions involved. The transaction itself might be, again, high risk, or might even be actually AML related. So in terms of the certain transactions, the company would need to identify and ask questions, and may need to also go into details as to the origin of the funding for the transaction and the origin of wealth of the client. Now, if there is any doubt, then there might be a need to make a suspicious transaction reporting, STR, which I'll go into a bit more detail in the next slide. But apart from this, this process would need to be ongoing, and the risk assessment needs to continue. And apart from that, there would also be the need for record keeping for a number of years of certain records. And also, there needs to be staff training for the staff to make sure that the staff knows about these AML requirements. So the current module would also be useful in terms of staff training for staff to understand all these requirements. Perhaps we can, yes, thank you. The other main legislation is the Organized and Serious Crimes Ordinance, or OSCO for short. And there are some other similar ordinances with similar wordings. This is important because this ordinance creates two main offenses that relates to AML. One is the offense of money laundering in relation to proceeds of crime. Now, if a person deals with crime proceeds, then that is an offense. And it also creates a positive obligation to disclose any suspicious property to an authorized officer. So that is why in the last slide I mentioned about under AMLO, certain circumstances you might need to consider filing the suspicious transaction report. Now this also, apart from the positive obligation, this also gives anyone who might need to deal with certain property or transactions a defense. If they make the report and disclosure and the relevant authorities confirm that there is no problem to proceed with the transaction, then that is a defense with respect to any AML allegations. So with this regime, there's also a so-called no consent regime that would be able to indirectly freeze certain bank accounts if any assets or money in a bank account is suspected to be crime proceeds. And all these also under OSCO, if the matter is really related to money laundering, the government also have the power to apply to confiscate the proceeds. I would just like to briefly also mention that actually there's also an ordinance that deals with the transfer of actual physical cash. And so now if a person comes into Hong Kong with a certain amount of currencies, then there is an obligation to disclose. So that covers the current regulatory landscape.
Great, thank you for that overview. So now we'll just move on into the details of the anti-money laundering and counter-financing terrorism module scope. So we've taken the information which Dominic has kindly provided an overview of and designed this module to target key aspects of compliance in this area. So the legal landscapes covers the following: Anti-Money Laundering and Counter-Terrorism Financing Ordinance, Drug Trafficking Recovery of Proceeds Ordinance, Organised and Serious Crimes Ordinance, Payment Systems and Stored Value Facilities Ordinance, United Nations Anti-Terrorism Measures Ordinance, United Nations Sanctions Ordinance, Weapons of Mass Destruction, Control of Provision of Services Ordinance, and the Cross-Boundary Movement of Physical Currency and Bearer Negotiable Instruments Ordinance. The module also covers the following regulators. So the Hong Kong Monetary Authority, Hong Kong Securities and Futures Commission, the Insurance Authority, Commissioner for Customs and Excise, and another 4 regulators. Our core obligations in a module can also be defined as key categories of tasks. And in this module, we have an overview, the requirement for AML CFT risk-based assessment, AML CFT systems for designated non-financial businesses and professions, customer due diligence requirements, simplified customer due diligence in low-risk cases, enhanced due diligence measures in high-risk cases, ongoing monitoring of CDD, prohibition on terrorist financing, financial sanctions and profiliation financing, reporting suspicious transaction and responding to law enforcement requests, record keeping, staff training, wire transfers, correspondent banking relationship, and establish private banking CDD. Now back to you, Dominic. Are there any new trends in AML CFT in Hong Kong?
Thank you. I would like to highlight a few new trends. One is the Hong Kong National Security Law, which is enacted in July 2020, and it created 4 new national security offenses. Now, it also gives the police power to freeze accounts and assets that are related to national security law offenses for up to 2 years. And same as the originally existed AMLO, it also created a positive obligation to disclose knowledge or suspicion of NSL offense. And actually, the Hong Kong Monetary Authority advised banks to file suspicious transaction report for dealings that may be related to violations of the HK NSL, which is on top of already their obligations to do so under AMLO and OSCO. So there are more burdens on banks, but actually not just banks, because this ordinance applies to all. And the second new trends I want to mention is the Securities and Futures Commission AML CFT consultation. So there are proposals to amend the guidelines to ensure that the industry players adopt a risk-based approach to AML and CFT measures, and also make the enforcement and compliance to be in line with latest international standards for AML measures. So if you are in securities business industry, then there might be more requirements to combat money laundering and terrorist financing coming. And the last one that I mentioned is just very recent, which is just two days ago, the Hong Kong government issued this public consultation to introduce a licensing regime to regulate the trading of virtual assets, including things like crypto assets and Bitcoins. So there have been recommendations by the Financial Action Task Force to ensure that the combat against money laundering will include also digital assets. So there is this consultation paper to introduce a licensing regime for these crypto exchange platforms. So any person seeking to conduct the business of virtual assets trading platforms in Hong Kong may be required, if the law passes in the future, to apply for license from the SFC. And so the SFC will be the regulator for these kind of business and digital assets trading platform. And so there is this requirement which may have a long-term impact if anyone is going into this business or may be interested in investing in crypto assets in the future in Hong Kong.
Amazing. So does the AML CFT Enforcement Authority have any priorities in 2020? And if so, what are they?
Thank you. We see certain trends and priorities for business in Hong Kong because, for example, there have been more enforcement against MSOs. We have seen more arrests, prosecution in terms of MSOs that have not been compliant with AMLO, and also revocation of licenses, refusal to renew licenses, or disciplinary matters. Now, of course, if one is not in the MSO business, that might not be directly relevant. But there have been many cases where sometimes you might need to use the service of MSOs, or some people might consider using underground money changes or wire transfer business for certain wire transfer requirements. Now, actually, sometimes these kind of wire transfer transactions are being used, they use MSO for that. So if they have actually higher enforcement against MSOs, there might be a risk that in this kind of transactions, the funds that you put through might be frozen if these MSOs might be involved in any investigations. So there is this concern. And also, of course, I mentioned already about the Hong Kong national security law. There have been a few high-profile cases of arrest and investigations and on freezing of accounts. And actually, there's now a hotline for people to report matters that might be related to NSL. And these new offenses, including one that is involving foreign country or with external elements to endanger national security. That might not be that obvious when businesses deal with other business partners. So there might be a risk that if one thinks that they're doing legitimate business with certain parties, there is a risk that one might be caught with this kind of issues. So it's very important to have more understanding on your business partners and KYC. And the last one I want to mention is that during this time of pandemic, there have been more reported cases of email scams and other scams. And actually the regulators have also reminded their members. HAMA has issued notices saying that Hong Kong have been impacted by criminals that have taken advantage of COVID-19 to try to perpetrate fraud or exploitation scams, for example, face mask scams. So there would be more joint efforts to try to curb this during this time. And so if one is into business where you might see new business opportunities, one needs to be very careful whether that might be actually a scam and try to avoid being caught into this kind of issues and where the bank accounts might be frozen due to this kind of AML related investigations. So those are the few key priorities I want to highlight.
Fantastic. So now just to wrap up, we do have some questions from our customers. Firstly, as an overview, what are the penalties for breaching anti-money laundering laws in Hong Kong?
Under I will talk about AMLO first. Under AMLO, if a person who is working for a covered institution knowingly contravenes a specified provision of AMLO, then the maximum term of imprisonment is 2 years and a fine of HKD 1 million. If the person does so with the intent to defraud the covered institution or any relevant supervisory authority, then the person may be liable to a maximum term of imprisonment of 7 years and a fine of $1 million. So these kind of criminal actions are resolved and settled through the judicial process. Apart from that, the relevant authorities that administer AMLO might have power to take disciplinary actions against institutions covered by AMLO. These actions include public reprimands, orders to take remedial actions, and orders to pay pecuniary penalties up to HKD 10 million, or 3 times the amount of profit gained or the cost avoided as a result of the contravention. Now, the other main legislation I mentioned, OSCO, which applies not only to banks, but everyone. There are 2 main offenses. One is the positive obligation to report. So failure to report, the maximum sentence is imprisonment of 3 months and a possible fine of HKD 50,000. And if one is dealing with property, that is quite a serious offense. If it is a serious offense under indictment, then the maximum imprisonment of 14 years and a fine of $5 million. For the lesser account of summary offense, then the maximum sentence is 3 years and a fine of HKD 500,000.
Wow. Okay. So what are some of the key compliance issues for organizations in this area?
So I think for organizations, I mentioned already about the Hong Kong national security law, and seems to be there's been an active enforcement on that. So one needs to be very careful to balance between this Hong Kong national security law and overseas sanctions. For example, there might be sanctions from other countries on certain people or businesses or transactions. And in order to maybe sometimes not to avoid that, then there might be a risk of violating the national security law. So one might need to be very careful, because I mentioned already that under the national security law, there is also the risk of assets that are suspected to be related to this offense to be frozen. And of course, the other thing I want to mention is that during this time of the pandemic still continuing and the economy of a lot of places are not good. Organizations would like to have more business, that's understandable. But if one is approached with some really too good to be true kind of business, then one needs to be careful whether that might actually be a scam or scam related business, which might then attract AML investigations or the risk of funds being frozen. So, and also in terms of the obligations under AML, all these new customers or lucrative transactions, one might need to be careful because there's an obligation for continual monitoring and risk-based approach to assess whether there's a risk of AML, and there might be a need to also make a report to the relevant authorities. So those are the key compliance issues I just want to highlight, especially during this time of the pandemic.
Fantastic. Dominic, thank you so much for your time. Really appreciate all your valuable insights into this world in Hong Kong. Thank you so much.
Thank you.